Hello and welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery, today called Important eDiscovery Case Law Decisions for June of 2024. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console. Questions will be answered both during and at the end of the webinar. And this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Kaylee Wallstad, EDRM's Chief Strategy Officer, is here. Could you please tell us what resources are available, Kaylee?
Absolutely. I always look forward to this monthly case law webinar. And we are also loving our On24 platform with so many more ways for you, our audience, to engage. And thank you to everyone who's doing the hearts and thumbs up. It's always fun for our faculty and Mary and I to see. If you check out your console to the right of your screen, you'll see a question mark icon. This is where you can type in your questions for today's faculty. Slides will be made available after the webinar has concluded. You'll also note the paperclip icon. That's for related content. And if you click on it, you'll see today's resources carefully curated just for you. The first is our On24 engagement tools description for you to download to help you better engage with the platform. There's also a link to subscribe to eDiscovery Today blog and never miss a thing. It's my favorite way to start the day. There's also a link to learn more about the Honorable Judge Peck and how to engage with him. And there is also a link to order your copy of Tom O'Connor's spicy new book, eDiscovery for the Rest of Us, recently updated in a collaboration with EDRM's trusted partner, NextPoint. And be sure to save your seat for next month's Case Law Edition on July 17th. And then up next on EDRM's webinar channel tomorrow, June 18th, public access or not, what can and cannot be protected from disclosure in litigation with the great Ron Hedges. And there's even more this week, so be sure to check it out. Speaker bios can be clicked and popped up to learn more about today's faculty. And then just like Zoom, our favorite tool on this platform, you'll see the smiley face emoji, and if you click it, you'll see many more reactions that you can click during the webinar, and we highly encourage you to engage with them. We're having a lot of fun with them on this platform. You'll see the Twitter bird, that's for social media, and you can follow EDRM and eDiscovery Today on LinkedIn. And back to you, Mary.
Oh, thanks, Kaylee. So our faculty, starting out with Doug Austin. Doug is the founder and editor of EDRM Trusted Partner, eDiscovery Today. Doug is an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published a daily blog since 2010 and has earned JD Super Awards 3 times. Tom O'Connor, who is the director of the Gulf Coast Legal Technology Center, is a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters, where he's worked with firms of all sizes, most recently the plaintiffs in the BP litigation. He's also been appointed as a technical consultant by various federal and state courts, dealing with large amounts of electronic evidence. And his most recent edition of his popular book, eDiscovery for the Rest of Us, was launched at Legal Week with EDRM's trusted partner, NextPoint, and is available for you. The Honorable Judge Andrew Peck is a Band 1 Chambers Rank Senior Counsel at DLA Piper, where he advises on copyright and trademark matters, and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first and most significant eDiscovery Opinions. EDRM is grateful to all three gentlemen for their service on the EDRM Global Advisory Council. And without further ado, Doug, do we have some cases to deal with?
Indeed we do, Mary. Thanks, and welcome everybody to our June 2024 Case Law webinar on the EDRM network, and belated Happy Father's Day to all the dads out there. We do indeed have another 6 cases to discuss this month, and those cases address disputes related to discovery of hyperlinked documents, boilerplate objections, fabricated video evidence, mobile device discovery and privacy considerations, pro se party request for video evidence, and the end of the DR distributors case, at least until the appeals start. As a reminder, of course, right? That's still going to happen, probably. As a reminder, we do welcome questions, and we'll try to get to as many as we can, and we will send a copy out of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Failing to acknowledge disclaimers could be considered by some to be plainly contumacious. And to find out what that means, we'll cover that later. Before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 36,300 lifetime federal and state case law rulings. This month, we're showing the state case rulings map, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. With this first case, I feel like I should start with, as we were saying, as we ended last month's webinar with 2 hyperlinked documents disputes, and start this month's with another one, and that's 3 cases in 6 weeks on this issue. In this case, following meet and confers, the parties submitted to the court their respective competing ESI protocols for the court's consideration, with briefing as to their positions. Plaintiffs also offered 2 expert declarations in support of their positions. Defendants submitted 8 declarations to support the proposition that no defendant has tools to automatically or comprehensively collect hyperlinked documents like traditional attachments, nor is there a way to automatically or accurately create family connections during the collection or review process. Plaintiffs replied to defendants' declarations seeking to further meet and confer on the issue. Plaintiffs argued that a producing party should produce linked documents with any affiliated family group, and argued that the parties should meet and confer as to the feasibility of producing hyperlinked documents in family groups. Defendants, in contrast, contended that plaintiffs' proposal was technologically infeasible, conflicted with ESI protocols entered into prior insolent pricing cases, and would create undue burdens disproportionate to the needs of the matter. They also opposed what they termed to be further discovery on discovery, and maintained their objections as to the production of hyperlinks that maintain any family relationship. As New Jersey Magistrate Judge Roxana Singh stated, in sum, each defendant proffers that it is not feasible, practical, or unduly burdensome to produce hyperlinked documents in family groups, particularly when attempting to produce in a family group the as-sent versions of any linked document. Her unduly burdensome statement there is probably a misstatement, as I'm sure she meant the defendants contended it is unduly burdensome. Regardless, she ruled on the issue by stating, the court agrees with defendants. Hyperlinks are not the same as traditional attachments. The court ultimately must determine whether commercially available tools that may be used to maintain family relationships in the context of hyperlinks are feasible in the data environments or systems used by each producing party subject to the ESI protocol, and if feasible, if the use of such tools are proportional to the needs of the case and not unduly burdensome. Additional meet and confers between the parties on this issue, as proposed by plaintiffs, would only delay discovery. Accordingly, considering the need for efficient and effective discovery within the court's discretion, the court adopts defendants' proposed language as to family relationships and hyperlinks in the ESI protocol. So, Tom, this is the second ruling in a row where the court has decided that hyperlinked documents are not attachments. Is the issue decided, you think, or do you think further rulings could still change things?
Well, I hope further rulings will change things, because I think there's a couple of things that aren't accurate here. And I mentioned it last month as well. To the extent that this court and the Judge Singh specifically mentioned Judge Quisneros and the StubHub opinion in the protocol there, the statement that there are not products that are technically able to do this is incorrect. Microsoft Purview in premium version will collect a hyperlinked document. It'll freeze it the way Purview does, and will also put a flag in to grab every change to that document that may occur, subsequent change to that may occur. So from the date that the hold is put on, if the document is amended or altered or changed 4 or 5 times, each one of those versions will be preserved. Now, in complete defense of Judge Quisneros and probably Judge Singh, that may have not been the case when these cases were briefed. I would say it almost certainly was not the case when the StubHub case was briefed. In the wonderful world of Microsoft, they release updates to products without doing things like, well, telling you that they did it. The fact is that Microsoft had been working on this problem for ages. Rocky Messing, when he was still employed at Microsoft, had approached me to help him write a couple of position papers internally about what needed to be done to address this issue. So they recognized it a long time ago, did something about it that was apparently in some sort of a beta or one of those buttons that doesn't work in the product. And then all of a sudden one day it worked.
Right.
I would think almost certainly the StubHub case, it was not active. I'm not sure about in this case, probably not as well. But the fact is, there is a product, that, at least one that can do it now. And we know for a fact that Google's working on it. Now, as you pointed out when we had a discussion last week with Sean Houston about this whole issue, Doug, that's great, but it doesn't go backwards. If I'm trying to grab a document today, that only helps me with documents today. It doesn't help me with a document that goes back. But that, I think, brings up the second problem here, is which is always in this arena, or often in this arena, we're conflating production with preservation. The question shouldn't be that I can't do it now when I want to produce the document. The question should be, what did I do to preserve the document when the duty to preserve arose? If I send an email to you, Doug, that says in its heading, "I shot the sheriff," and I say, take a look at this document that I wrote that outlines all the different ways that I get involved in that gunfight the other day outside of the Orleans Parish Prison, it clearly has to do with the topic, and a litigation hold goes on to the email. Clearly, that document is relevant, and a hold should go on to that document as well. So the question really should be, when did the preservation obligation arise, and what did you do to get that document then? Not 6 months, 9 months, 10 months later, I can't produce it now because it's so hard for me. I think we're ignoring the need to look at what the preservation obligation was. And even in the good old days of eDiscovery, when we couldn't deal with backup tapes because it was so expensive to try to get them out, we still had to preserve them. We still had to set them aside and say they're there in the case that the technology changes, and we can get them, which it did, and we can. And I think that's going to happen here as well.
Yeah.
That was almost as long-winded opinion as one of our favorite judges later.
No, but you bring up a lot of great points, Tom, and certainly the technology is changing. One of the things you mentioned, of course, I mean, they were very quick. This ruling came out on May 28th. I think the StubHub one came out on like May 20th, and within a matter of a couple of days, they submitted that as another. The defendants did as another point of to push for them on that. Also, one of our audience members, of course, mentions with regards to Microsoft Purview, that's the E5 license only, but not the E3 or other licenses that provides that ability for. Yeah, so that is it's not available for everybody. Hopefully,
no, it is definitely the premium E5 license, which is not cheap. But I think StubHub could probably have afforded it.
Yes, and most of these cases are in-ray cases. We've been covering this issue, which I think means that a lot of these defendants could afford it, but nonetheless, it is still a consideration. So, Judge Peck, one of the things notable here is that Judge Singh chose not to have the parties meet and confer again once more on this issue. Do you agree with her decision not to have them meet and confer once more on such a complex issue?
Yes. Courts have to balance the, due process rights of all parties. Have the parties had enough notice? Have they had the chance to meet and confer? Versus, is it extremely unlikely they're going to reach any agreement and of a further meet and confer? All that has to be balanced. And here, as she said, quote, additional meet and confer between the parties on this issue would only delay discovery, close quote. I think she correctly did that balance. Certainly once she read the expert submissions, declarations, whatever they were, to which there did not seem to be, at least from the reported decision, any contrary material from the plaintiff's side, I think that was pretty much ball game over as to whether a meet and confer would achieve anything. Plaintiffs should have hired Tom, and they might have had a better outcome.
Right. Yes.
Yeah,
there you go. Of course, that goes without saying, but good to say it anyway. Definitely getting some comments on this issue. But first, Mary, I'll ask you a question. Do you think there's anything the plaintiffs could have done to achieve a different outcome, or is this the best they can do given current technological limitations?
Well, I've been puzzling over this whole hyperlink file situation since our last case law. And certainly in light of how eDiscovery's evolved over the last 25 years, it's been judicial imperative that has moved our technology forward in terms of versioning or getting things out of archive systems that might have been problematic or things of that nature. So we do have Sedona Principle 6 that says responding parties are best situated to evaluate the procedures, methodologies, and technologies appropriate for preserving and producing their own electronically stored information. I wonder about regulated industries using this and whether or not they're able to produce the way that they need to their regulators, given this technology. But the plaintiffs might want to read Leah Bayes and Stuart Davidson's article, May of 2024, in the University of Cincinnati Law Review. Leah and Stuart have an entire work plan, all annotated with citations there. And one of the things they mention is a product called Metaspike, which I have not used, but may be able to handle this from a technology situation. The other thing is that there are archiving systems like Smarsh, Barracuda, and some of those systems. And the plaintiffs could look through the evidence that was produced to them to see if any of the hyperlinked material made it through somehow, or to other regulatory events or other litigation where the defense was able to produce those items. And they could also ask that evidence offered is favorable to their cause, and part of this hyperlink situation be excluded. And so those are some of the things. And then one of the judges in the cases that we looked at previously allowed for 200 to 400 selective emails. So if they're able to see what the time frame would be that would be most important for relevant material, and then the individuals, they might be able to narrow that down fairly expeditiously to request selective emails be tweezered by hand.
Right. Tweezer, that's a good way of looking at it. And yeah, so certainly a couple of comments from the audience here, a couple of comments and questions. One of the audience members, of course, notes with regards to Purview, and you have to process in Microsoft in order for Microsoft to link the documents, which of course, that's part of the problem, is that people have had a lot of issues with Purview and how well it does eDiscovery, which is part of the challenge there. So certainly that's a consideration. Another one here, shouldn't all questions about hyperlinked documents turn on whether the hyperlinked document itself is relevant and discoverable, or if not, whether the hyperlinked document is necessary context, i.e. discoverable per the rule of completeness and Federal Rule of Evidence 106. And certainly one of the things I've been pointing out is these documents, if they're relevant, should be produced regardless, even if you're not able to make the link. It seems to me like these repositories should be searched for relevant documents, and relevant documents should be produced. So that's one of the things that was one of my assumptions in my 5 assumptions post a few months ago about this issue. Is certainly we're not saying the document shouldn't necessarily be produced. If it's responsive, it should be produced. But the question is what is your requirement to establish the link? I honestly think that that's one of the challenges, is that sometimes it may not necessarily be relevant on its face, but it might be relevant in conjunction with the email. So which is the necessary context. So I don't know if any of you all have thoughts about Matt's question there.
I mean, the only thing I would say is that was the ruling in Noom,
Right.
or the party agreement, however you want to look at it, that the repository where the linked documents resided was independently searched for relevant documents. They just couldn't link it back up to the parent in quotes email.
Yeah, absolutely. And another thing that I'll note here, because Mary mentioned several tools, and certainly some of them are great tools. I've heard a lot of great things by a forensic email collector from Metaspike, FEC in particular. But of course, an eDiscovery tool can only do so much. If the version of the file is no longer there, you obviously can't collect what isn't there. So certainly that comes into play as well. And I'll hit a couple of these others real quick before we move on and get into race car mode for our other 5 cases. So another comment here, I find many of the discussion regarding linked files have become ideological in nature. The decisions and opinions regarding linked files today will not have a long life. Today, there are substantial burdens with reassociating linked files with their referencing email. This will, however, become less burdensome in the near future. Microsoft may have to listen to its customers to achieve this faster. Couldn't agree more, and I think this will become less burdensome, and I do think that both Microsoft and Google will have to listen to their customers in that regard. And then a question.
Sorry,
go
Doug,
ahead.
but,
Yes.
It's important that lawyers arguing the next linked document case, or the linked document case that comes up 6 months from now, doesn't just say, well, 3 courts have held X, but rather what is the current state of the technology as time goes on.
Exactly. Right. Which is why I think that we haven't seen the last on this, and this issue will evolve as we continue to see some of these cases. Very quick, Sheila had a comment. What if you need it and want a discrete set of attachments? What do you suggest? The attachments are proposals that go to the hearts of the issue. Well, certainly in some cases, what the courts have said is, we'll give you X number. We'll give you like 200, and and say these are for these emails. We'll agree that the producing party will go pull those attachments. So they've kind of, it seems a bit arbitrary, but that seems to be the best they've addressed it so forth. So I think to some degree, probably a requesting party has to start thinking about which attachments or which linked files they want the party to produce to pull most directly. And then one last question here: isn't the whole issue on hyperlinked documents the as sent version, which Judge Cisneros called the contemporaneous version? In order to preserve the as sent version, the company would have to turn on the necessary settings before any litigation starts. Certainly that's a big part of the issue, but I don't think it's the only part of the issue. Sometimes it's still difficult getting to the document, regardless of whether it's the as sent version or not. I think that's getting easier, but I do think that is still a challenge as well. In some instances, it's not automated. I do think that's a case where if the as sent version is not the issue, a tool like a FEC can pull what files are there. And that could be a consideration. But yes, the versioning is certainly a big part of it. What did they see and when did they see it is a big part of this discussion that underlies it all. So I should move on to other cases because we have 5 to cover. So we will go quickly. In our next case, which was suggested by Judge Peck, who had a lot to say about the use of boilerplate objections in the Fisher v. Forrest case over 7 years ago, yet we still see them. So I will allow you to read most of the information here, but in essence, what I'll say is eventually the plaintiff filed a motion to compel seeking production of documents contending that the defendant Cardamone's objections were boilerplate objections and should be overruled. And in the second and third bullet points that you see there, you see an example of one of the requests, including search terms provided by the plaintiff, and Cardamone's objection to the request, which included the language on the basis that it is vague and incomprehensible as written. So they refused to provide any documents unless the request could be clarified. Florida Magistrate Judge John Flynn wasn't a fan of that response, saying the court finds that Cardamone's objection to the request should be overruled. As a preliminary matter, the objection is boilerplate and that it does not explain how the request is vague or what Cardamone fails to comprehend about the request. Moreover, while Cardamone's client might be unfamiliar with electronic discovery practices, it is its counsel's responsibility to assist with this process. Cardamone had similar objections to other requests, but did respond to the plaintiff's motion with some additional comments as to why they found the request vague, as you see in that fourth bullet point. But still, Judge Flynn wasn't buying it, saying the court finds that the request is neither vague nor incomprehensible, while Cardamone raises various potential interpretations of the request and its response. An attorney receiving a request for documents has a responsibility to reasonably and naturally interpret that request. He found most of the other objections to be boilerplate and overruled them as well. And he awarded expenses and attorney's fees regarding the first RFP, stating, as discussed above, Cardamone responded to the first RFP by lodging boilerplate objections, which cannot be considered substantially justified. Furthermore, even Cardamone's post hoc justifications for its boilerplate objections were not persuasive. So Judge Peck, in some cases, the defendant provided additional questions to clarify their request, but only after issuing a vague and incomprehensible as written objection first. If they had led with those and you were the judge, would you have still overruled their objection?
I mean, maybe. Once you've started with a boilerplate objection, which is basically a waste of the 30 days or more that one has to respond, and then you try to fix it later, the judge will become aware of the original boilerplate, and it's a sort of rule 1.1, don't piss off the judge. Every objection, here's, practice point, perhaps obvious for the attorneys in the audience. Every objection should have a because part of it. It is overbroad because, and then explain, etc. As a judge, you want to be fair, but judges really are fed up with boilerplate objections. I mean, I was fed up back in 2016 or 17, whenever the Fisher versus Forrest decision came down. And believe me, there is a similar decision basically in every district. You know, and whatever one may say, and I know you're going to address that with Mary about the search term request, the broken down by month and year, for someone to say that that is meaningless, every single request for time immemorial has tried to say, you know, we need it monthly, we need it quarterly, we need whatever. And, you know, if there is vagueness in the request, the responsible thing to do is not just say, I don't understand it, but, you know, a reasonable interpretation of this request is X, and that's the way we're going to respond to it, you know, and if necessary, we'll have a meet and confer about it. I suggest everyone reads the Sedona Conference primer on Rule 34 responses, available for free off the Sedona Conference website, which has lots of similar tips on how to respond to what may well be bad requests without getting in trouble yourself with the court.
Sure. Speaking of bad requests, we have a comment from the audience, but first, Mary, I'm going to ask you this question since it ties in. So Mary, Craig Ball pointed out in his blog post last week that the plaintiff's request number 7 included W/S within sentence operators that most eDiscovery platforms don't even support. In fact, I don't know any of that do. So given that limitation, should the defendant have another chance to negotiate the search term?
Well, it's really interesting because certainly the within sentence could be, you could, you know, reasonably get to the same thing with a within 20, within 25 or something like that. It might be a little bit overbroad that, and not like a short sentence worth. But in the spirit of cooperation, absolutely, they should have another chance to negotiate the search term. But then if this was presented in such a way as it's this way or the highway, then they put that syntax into their tool and they get what they get.
Right, which is what Matt Linehan pointed out. They could have just tested the poorly written search in request 7 and get 0 hits and say there were simply no documents responsive to the request. So that's, you know, they clearly didn't recognize just how bad a search it was. And certainly we see that all the time. So Tom, in one of the responses, the defendant noted that they only have 2 employees as explanation for their response as to burden. So should a small company like that be given a little more leeway in a case like this?
Well, I think they are under the rules. The 6 factors for deciding how to decide all this. The 4th one is the party's resources. They might have been better off arguing that a little more strenuously than some of these other boilerplate things. Although I got to say, you know, Mary mentioned the spirit of cooperation. You know, a good meet and confer, it seems to me, could have solved this by just coming in, instead of going with all this syntax language, saying, hey, here's what we're looking for. You know, we want all the places where Acme is mentioned within the same paragraph as Roadrunner. Can you find that? Don't try to show your technological prowess by giving these syntax, you know, specific syntax requests. I think Craig Ball wrote a column about this recently where he said, you know, every search product out there is different. Don't assume that just because that's the way you do it, that's the way the other people do it. But it seemed to me like a cooperative meet and confer could have resolved this really way, way ahead of time.
But
certainly,
you know, the other point I would make is that, and you know, there's something Judge Flynn said in the opinion that made it seem like the defendant was arguing that its employees would be doing the search, not counsel. You know, with eDiscovery, we're not saying that somebody should look through every document by hand. There are tools, and the search should be done, or certainly very closely supervised, by counsel. So the two-employee argument gets you a little bit of mercy, but not probably as much as defendant was hoping for.
Yeah, certainly fair point, and interesting case, and certainly cooperation and a little bit of eDiscovery education would have gone a long way here. So we'll move on to the next case. And really the title says it all. This case was also suggested by Judge Peck. And essentially it came down to the authenticity of a video that was produced by the plaintiffs, which showed a mound of bloody materials in a kidney-shaped dish. They asserted that they recorded the video during Mr. Frazier's follow-up visit in the doctor's office a few weeks after the initial procedure. Both the parties in the court referred to this as the U-Cut video because it was created by Mr. Frazier using the U-Cut editing app to combine two separate original videos, which he claimed to have recorded on his cell phone. Naturally, the defendants wanted to see those original videos and associated metadata, but they only got a screenshot of a purported original video, which purportedly displayed some of the video's metadata. So then the magistrate judge ordered a forensic examination of Mr. Frazier's phone, but the defendant's expert couldn't locate the original video files to determine whether the video was authentic. So then the plaintiffs, not the defendants, the plaintiffs requested to inspect Suite 480, where the original videos were purportedly taken, and have a videographer record the inspection. So the plaintiffs conducted their walkthrough with videographers present for both the plaintiffs and defendants, and the inspection revealed significant discrepancies between the features of the room in the U-Cut video and the room where the exam occurred. So the defendants filed a motion to dismiss the case due to plaintiffs fabricating a video, and the magistrate judge recommended the court dismiss the plaintiff's suit with prejudice. Georgia District Judge Lisa Wood stated, plaintiffs contend any sanctions based on the court's inherent power would be improper. Plaintiff's argument in this respect is wrong. And because the concept of bad faith clearly embraces fabricating or destroying evidence and then lying about doing so, exercise of the court's inherent power is warranted in this case. Contrary to plaintiff's argument, the conduct in this case, doctoring evidence, is most often the cause for invoking the inherent powers doctrine. Also noting that the plaintiffs had not produced the original videos, Judge Wood stated, defendants have proven that plaintiffs fabricated the U-Cut video because they've proven that Mr. Data did not record the U-Cut video in Suite 480. And she referenced the Rossbach case that we've discussed a couple of times in our webinars, stating in dismissing the case with prejudice, plaintiff's argument that a jury should make factual determinations regarding the U-Cut video's authenticity is unpersuasive. This case more closely resembles those where courts have concluded that evidence was fabricated and ordered dismissal sanctions without the assistance of the jury. So, Mary, this video was apparently an obvious fabrication, but AI is making it easier to create very convincing deepfakes. So what advice do you have for our audience to authenticate evidence that they suspect to be fabricated?
Well, certainly you'll want to challenge evidence that you suspect of being fabricated. But first you want to determine its relevance and its importance to the case. And if it's important and relevant, then to challenge it as was done here, trying to look at metadata, not just the file envelope, but also in the case of video, the video metadata, like with location data, cameras and such, triangulating with calendars, other pictures of video and audio of the same people, places, things, or time frames, testimony. And then also there are emerging platforms now that have deepfake detection technology. One of our newest partners, Clarity, has that available. And so I think this is going to be quite the thing going forward, figuring out what's real, what's not real, and what should be put forward and what should be challenged.
Yeah, I couldn't agree more. And it will be interesting to see that. And certainly the deepfake detection technology, I think, is going to become much more important as things go along. So, Tom, I'm curious, why do you think the plaintiffs requested to inspect the suite where the procedure was performed, given there were significant discrepancies from the room depicted in the video?
Well, I think it's an authentication issue. I've got to say real quick, though, if I might, I just received a text from David Horrigan telling me that in the in the StubHub case, I've been mispronouncing the judge's name. So not only have I called her opinion into question, but I've mispronounced her name publicly, which, is always a great way to start off the day. And that he believes she pronounces her name Cisneros. So my apologies to the judge. On the Frazier case, I mean, it was an authentication issue, right? The U-cut video, which everybody agreed was not the original. The defendants requested the original, and as well as metadata, in order to verify the authenticity. The plaintiffs couldn't produce it. They produced instead a screenshot of the purported original video, which purportedly showed some of the forensics metadata. Excuse me. The judge then ordered a forensics examination of the phone, but the defendant's expert couldn't find the original videos on the phone. I'm curious as to why they didn't move to have some sort of sanctions right then. I mean, they want to look at the room, but the neither the original nor examination of the phone itself that purportedly had the originals showed the original, the actual original. I mean, I'm curious why they didn't move on that. But I think the point of examining the room was to further display that the video was incorrect.
Yeah, although I was still surprised, though, again, that it was the plaintiffs who requested to do that, considering they were the ones who, I think were trying to defend the video. I don't know if they thought maybe they could pull one over and have their videographer record it in such a way where it would look like it matched up or what. But that to me was surprising that the plaintiffs requested it.
Or I wonder if plaintiff's counsel did not know what the client had done. And so counsel thought, this will be great for us.
We'll just take a look at the room. Yeah.
That's a fair point. That's a fair point. So Judge Peck, when a party fabricates evidence like they did here and in the Rossbach case we covered a couple of years ago, should dismissal always be the resulting sanction, or is there a circumstance where the case could be allowed to continue?
Now, always, like certain discovery requests, is probably overbroad. Nothing is ever always, or the converse of never. But where the fake evidence goes to the heart of proof of liability in the case, then I think dismissal is appropriate. Maybe, if the fake evidence went not to the merits of the case, but the amount of damages or something else that's more peripheral, then lesser sanctions may suffice. But if it goes to the merits, sort of the don't do the crime if you can't do the time, if you're going to fake evidence to prove your case, the court has every right to say, that's a fraud on the court, get out of here.
Mm-hmm. Yeah, couldn't agree more. Question from the audience. Does the panel think different sanctions would have resulted if the original video was recovered and the defendant was able to use that original video to potentially resolve plaintiff's claims on the merits as opposed to sanctions? Well, certainly Judge Wood, said that was one of the keys that plaintiffs have failed to produce the original videos. So certainly I think that it could have been different had the original video been recovered, and maybe they would have been able to use that to illustrate it as well. But any thoughts from any of you on that?
Yeah, I agree. And, this was not one of, 50 photographs of the kids on vacation or something. This was obviously something very important to the plaintiff. And you would expect the plaintiff have been very careful, particularly once advised by counsel, to preserve it even after making the U-cut video.
Indeed. And the fact that they didn't might be telling. So with that, we'll move on to our next case, which is a state case. And it was another suggestion by Judge Peck. This was a dispute between former domestic partners with several claims, including claims of abuse, assault, defamation, and intentional infliction of emotional distress. And in it, Swayze filed a request for a forensic review of Roque's cell phone, seeking to have a forensic expert copy the entire contents of Roque's cell phone, including all data and metadata, and including deleted items. However, the Third District Court of Appeal of Florida noted in this ruling early on that, importantly, although Swayze stated in this request that he believes it is necessary and timely to request forensic review of Roque's cell phone as to analyze and prevent spoliation and promote efficiency, Swayze did not proffer any showing nor even allege that Roque had destroyed or deleted or threatened to destroy or delete any data or evidence, or that the requested forensic review was the least intrusive means available to obtain the information sought. The court also noted that the lawsuit was in its infancy at the time of the request. Roque objected to the requested forensic copying and review of her entire cell phone, asserting it was a violation of her right to privacy, and that Swayze offered no legitimate justification or need for such intrusive discovery. However, after a hearing, the trial court granted Swayze's motion for forensic review and submitted an order for a forensic image. The order directed Swayze's attorney to choose a forensic expert without input from Swayze to be approved by Roque and her attorney, with a copy of the cell phone's contents to be reviewed by Roque's attorney and relevant data produced. Florida appellate court saw it differently. Considering a request for certiorari relief, the court stated the parties do not dispute that Roque has a reasonable expectation of privacy in the contents of her cell phone, and that the trial court's order granting access, even if such access is limited to Roque's own attorney and a forensic expert to image the data and metadata, would constitute an invasion of Roque's privacy rights. Whereas here, a reasonable expectation of privacy exists for the information, data, or items ordered to be disclosed. A trial court is required to balance this right against the need for the discovery, and the burden is on the party seeking disclosure to establish that the invasion of privacy is warranted, and the least intrusive means are utilized to obtain the discovery sought. The court granted the petition for certiorari and quashed the trial court's order for a forensic image, saying we reject Swayze's position, as argued to the trial court, that this proposed forensic review should be permitted as a quicker and more efficient means of obtaining evidence. Such a contention is reminiscent of arguments advanced to justify warrantless searches otherwise prohibited under the Fourth Amendment. So Tom, how should Swayze have pursued discovery of VSI from Roque's cell phone to get the information he sought?
Well, I think first of all, he maybe should have taken a deep breath and waited a little bit.
Right.
As the court noted, at the time of making this request for forensics review, the lawsuit was in its infancy. Discovery had just commenced. Swayze filed his initial discovery request the same day he sought forensic review of the cell phone, and thus no responses to the initial discovery were due. I mean, he might have made his move too soon, right? Wait till you get some of those discovery responses back. The other thing, though, was the court stated, again, quote, importantly, and anytime a court uses the word importantly, you probably want to pay attention to the couple of sentences after that. Swayze stated that he believed it was necessarily and timely, but he did not proffer any showing nor even allege that Roque had destroyed or deleted or threatened to destroy or delete any data or evidence, or that the requested forensic review was the least intrusive means available to obtain the information sought. So just, a couple of tactical notes there from the court.
Yeah, absolutely. So Judge Peck, are you surprised that the trial court granted the request for a forensic image, given that it was so early in the case and that Swayze hadn't demonstrated that Roque had spoliated any data?
Since we spent so much time on hyperlinks, my answer is yes.
Fair enough.
Nice.
I think that we pretty much all are. So yes, we'll move on from there. Simple enough. So Mary, with mobile devices becoming increasingly relevant in discovery, what recommendations do you have for our audience to help ensure that mobile device ESI is preserved and properly collected for discovery?
Well, the first thing is to find out how the custodian uses the device and how they back it up, if they back it up, or if perhaps their organization backs it up. If so, you've got it preserved. If the settings are set right to preserve the things that you need to inquire about that. eDiscovery platforms like our trusted partners Celebrate, Mode One, Xtero, they all have ways to get at this. And I would say don't wait. Phones go missing, they get damaged, and they're frequently updated.
Yeah, absolutely. So that's regardless what has got to be produced, got to preserve it. I got to say, very active audience today. A lot of comments and questions, and so definitely digging it. Moving on to our next case, another appealed ruling, this time at the federal court level, where Mutchler filed suit pro se, raising claims regarding his treatment in prison, including claims related to his urinary incontinence. First of all, the district court granted summary judgment for the defendants, but then the Third Circuit affirmed in part, but vacated and remanded on Mutchler's claim that defendants violated his Eighth Amendment rights. So on remand, the court denied Mutchler's renewed discovery-related motions, which primarily sought video footage of a housing unit and cell. And they also denied his renewed motion for appointment of counsel. After a bench trial, the court concluded that the Tritt and Manback did not violate Mutchler's Eighth Amendment rights because the conditions in his cell were not sufficiently serious, and they did not act with deliberate indifference. So Mutchler appealed again. The Third Circuit Court stated Mutchler has been requesting video footage of his housing unit and cell for specific dates and times since a discovery motion that he filed in 2015. Such footage would appear relevant to these claims, and no one has argued otherwise. Instead, defendants argue that Mutchler is not entitled to relief on appeal because he's not shown prejudice. We disagree. Defendants argue that Mutchler has not specified what the video would show, but he has made a sufficient showing on that point. Defendants also assert, as they did in the district court, that they actually made the video available to Mutchler, but Mutchler vigorously disputed that assertion and continues to do so on appeal. His arguments raise a legitimate issue regarding whether defendants made the video available, much less in a way that would have allowed him to use it. The court added, in vacating and remanding the district court's denial of requests for video footage, Mutchler had indeed responded to the April 3 order before the discovery deadline expired with a motion that should have drawn a substantive response from a magistrate judge, but did not, given the importance of the video to a claim that we remanded on and on which the court scheduled trial. Mutchler's pro se filing should have led the court to resolve this discovery issue on its merits before conducting that trial. The district court never addressed the relevance of the video or the dispute about its production. Instead, the court consistently faulted Mutchler for failing to properly raise the issue pro se. The courts tend to be flexible when applying procedural rules to pro se litigants and are especially likely to be flexible when dealing with imprisoned pro se litigants. Those principles should have led the court to resolve this discovery dispute on its merits. So, Judge Peck, how flexible should courts be with pro se litigants? Do you agree with the Third Circuit that they should have been more flexible with the plaintiff here?
Yeah, you have to be very flexible. These are not lawyers. They're, sometimes have other problems. You can't allow disobedience of the rules, but at the same time, you can't expect the pro se to the minutia of the rules. You have to do this within X days, or you have to, include a brief, not just an affidavit. I mean, many times what the pro se submits is a handwritten, and sometimes, and I'm not being facetious, written in crayon. They have minimal access, if they're imprisoned pro ses, to the law library, which is the only area there's likely to be a computer. So you got to be able to read through a lot of excess verbiage, a lot of nonsense, to see what they're really saying. And I would have to say, taking a leaf from Doug's pun dictionary, that the trial court did a piss poor job of dealing with it.
Oh my
Oh,
word.
Ouch.
Judge Peck. Oh
Ooh.
my goodness. Wow. Okay. I will. I will move on. Uh, Mary, the plaintiff had been requesting video footage since 2015, and the parties disputed whether he had been given access. So, with the trial court having ruled against the plaintiff before the Third Circuit reversed and remanded, what do you think the chances are that video is still available after all these years?
Well, if they didn't give it already, I think it's highly unlikely. We've seen the really short retention policies and practices on these systems, in cases over the years. So I'd say it's highly unlikely.
Yeah, I agree too. So, Tom, why would a court deny appointment of counsel? It seems like that would be a good thing to enable a pro se party to get the help they need.
Well, clearly the appellate court thought that. You got to remember, this is a civil case, not a criminal case. So it's discretionary, as the judge pointed out. The discretion to appoint counsel for an indigent plaintiff is really well laid out, and the court referred to it in the Tabron case, a 1993 Third Circuit case, which is, if you want to take a look at the factors to be considered for this sort of a decision, incredibly well written, well laid out, well thought out, great, just a real pleasure to read in terms of jurisprudence and clear writing and reasoning. It's a great decision. And the factors are out there. The court found that Muchler had shown and this is an important factor, a clear ability to litigate the case. And really that's one of, not the most important, but literacy, capabilities, all of those things are. What's really important, I think, here was that the court noted that the district court was familiar with Muchler after years of litigation. Hope I'm not butchering his name the way I did the judge's name. Expressly considered his ability to present the case as a whole and weighed that factor along with the other Tabron factors. In other words, he was a good, if you'll pardon the term, he was a good jailhouse lawyer. And he was doing a good job. And those are sort of the factors that are involved. The court did leave it open for reconsideration and even consideration sua sponte, which is also allowed. So,
Sure.
And just to be clear, the courts have no budget, no money to pay for lawyers for pro se. So it's really doing a certain amount of winnowing using those factors or the equivalent in other circuits. And then you got to put out a call for volunteers. Is anybody willing to take this case on? Usually as a way of training young associates under the supervision of a more senior lawyer. But it's not like the court can say, okay, we are going to hire X or, put it out there for anyone who wants it, and they're going to get paid even the lowest hourly rate that goes to Criminal Justice Act attorneys.
Yep. Yeah, I mean, that's a great point. The Tabron case talked about that extensively. It talked about both those points, budget and volunteering. And you're right. The federal defenders at least have a budget as limited as it is. The court can tap into some money to pay them. Civil case, that's not going to happen.
Couldn't agree more. I moved quickly to the last case slide, and we've got 2 minutes to sum up a case that's taken 12 years to resolve. So no problem, right? This is the purported final ruling on one of the most famous or infamous cases in the eDiscovery history, the DR Distributors case. In this 12-year-old case, Illinois District Judge Ian Johnston opened the case with this statement: "By far, this case is the oldest rat in the barn. Resolution of this case has been, resolution of this case has been repeatedly stymied by Brent Duke's actions and inaction. Extreme prejudice resulted to plaintiff, to the court, and to the other litigants attempting to have their cases resolved. Too much time and energy and too many resources have been unnecessarily spent on this case. The litigation in this case has resulted in numerous court orders, many of them caused by Duke's misconduct. This order will be the court's last. The court is entering case terminating sanctions." And then he proceeds in an effort to avoid another quote unquote War and Peace ruling of 200 plus pages that he issued in 2021, gave us a mere 30 pages to discuss his reasons for dismissing the case. And you see some of the notable statements there, which to a large degree associated with the considerations regarding the identification of 20 bankers' boxes of hard copy documents that came into play after his ruling, his sanctions order of February 2021, and the fact that Duke had not paid or even tried any sort of effort to pay the fee award of over $1.26 million. And so, as you see there, Judge Johnson also did rejecting some contentions that the case had meritorious counterclaims, and he illustrated his points there as why he thought they didn't, as well as that he found that Rule 26G, Rule 16, and Rule 26E were violated. So instead of reading that, I'll let you all read it, and I'll ask you, Mary. One of the things that Judge Johnston mentioned a couple of times is how the plaintiff and defendant present in court and their respective levels of success as businessmen. So why do you think he thought it was important to mention that?
Well, he was going to, one of the things he said was the court was left with the firm conviction that Duke took advantage of the ineptitude, carelessness, and disinterest of his attorneys. And then some of the evidence that was put into this case, financial records established that 20th Century Smoking produced very little income. His primary source of income is driving for Uber. So in terms of, are there counterclaims that that should be addressed, I think he wanted to get rid of that part there.
Yeah, certainly makes sense, and very interesting to learn a little bit more about Brent Duke in this ruling. So Tom, do you agree with Judge Johnston that Duke's failure to pay or even come up with a plan to pay was plainly contumacious?
Contumacious. Ouch. Yeah, of course. And you know what? The judge used that word 6 times in total, contumacious, and each time gave a specific example of the contumaciousness exhibited by Duke. So he didn't take that point or any of the others lightly. Obviously, when you start the case off by saying this is the oldest rat in the barn, it's all going to go downhill from there, right? My personal favorite quote of his was, "The court wishes it could live its life outside this case."
Right? Yes,
he was done.
Yes, I understandably. And by the way, so for those of you who didn't know before this ruling, like me, what contumacious means, it means stubbornly or willfully disobedient to authority. So that was certainly a learning lesson for me, and maybe for some of you as well.
And I'll add to that, Doug. In Blacks, it says refusing to obey or respect the law in a way that shows contempt.
Yes, indeed. Well, and certainly understandable that Judge Johnson would find that his actions rose to that level. So I'm curious. Yes, indeed. So Judge Peck, I'm curious, why do you think Judge Johnston let this case go so long without issuing terminating sanctions? If you were the judge, would you have let it go so long?
Probably not. But, you know, one of the things here is this case was originally before a prior district judge on the matter. It's unclear when within the 12 years or whatever of the case it went over to Judge Johnson's docket. You know, I think if he had had it from day one, he would not have had 12 years worth of patience. But the second thing that ties in with that is that the prior judge found that Duke was the senior user of the phrase 21 century smoking, which means that under trademark law, it's not dispositive, but it is a very important factor that would lean towards finding Duke to be the prevailing party on the trademark. claims. So when somebody otherwise has a good case, it is much harder, or it should be harder, to give sanctions that dismiss that party's case and default them on the other side's case. You always want the strongest record possible to uphold what you've done when it goes up on appeal. And I'm sure Judge Johnson wants this really to be his last DR distributor's decision, and by making it strong and somewhat redundant in that there were two separate paths, the failure to pay the money and then the boxes and boxes of documents, he did not want it to come back on a remand. One other personal note here, I think the War and Peace reference where Judge Johnson said, "I'm not writing another War and Peace," was a silent shout out to me, because at one conference where he and I were both present, I referred to the first DR distributor's decision as his version of War and Peace.
No. Well, there you go. Now we know the inside story behind that comment, because I did not know that. Yeah. A couple of things. Certainly, first off, if this does go to appeal, you have to feel for the appellate court that's going to have to read all the history of this case, because that's going to be quite some reading there. I will note that I think Judge Johnston has been district judge for about 4 years, but I did go to earlier rulings, and it does look like he also had this case for a while as a magistrate judge. So
yes,
he probably got it again, so he has suffered with this case for a long time. So certainly an interesting case, and we will see if we have indeed seen the last of the DR distributor's case or not. But in the meantime, here's our contacts page, and our next case law webinar is exactly 1 month from today, on Wednesday, July 17th. And there's a cake with 4 candles again, which means we'll be celebrating something. And to find out what, you'll have to register for the webinar. 3 guesses and the first 2 don't count. So with that, I'll say thanks to Mary, Tom, and Judge Peck. And thanks to all of you for your great comments and questions. I'll turn it back over to you, Mary, to close us out.
Thanks, Doug. Well, we thank you, of course, Doug, for anchoring, and Tom O'Connor and the Honorable Judge Peck for this insightful presentation. Our thanks to the EDRM community for your kind attention, for your questions, and for your emojis. And if you really loved it, show Judge Peck, Tom O, and Doug Austin from Houston some more love. Find those emojis at the bottom of your console, and to be automatically registered for on-demand webinars, click the pop-up at the conclusion. Once there, click the bell to subscribe for updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Bye, everybody.
Bye-bye.
bye all.